The International Criminal Court's ruling on Monday that 4 of the 6 prominent Kenyans suspected of orchestrating post-election violence in 2008 will face trial is sparking debate in the East African nation. As the country gears up for the general election later this year, the implications of the trial are enormous. Earlier today, I spoke with Barrak Muluka, a Nairobi-based political analyst, and asked him how the ruling will affect 2 of the accused, Uhuru Kenyatta and William Ruto, who have both declared the intention to run for the presidency.
According to our laws, Vincent, there's nothing to stop them from vying for the presidency because our law says that you can only be barred if and when you have been convicted, and the conviction has also gone through the appeal stages, and that you have lost all the way. Of course, there would be logistical and other functional considerations, such as if the trial were to begin and they were required to attend court proceedings, that would impede their being available on the ground for the essential political mobilization and participation in campaigns. It's also possible that if the ICC were to consider it necessary to freeze their resources, then they would also be challenged in a fundamental way.
Yes, right from the onset, those mentioned by the ICC wanted to portray this as political manipulation, particularly to benefit Prime Minister Raila Odinga. To what extent do people you speak to the citizens, see it the same way?
One would look at that, Vincent, from 2 platforms. First, there's the platform of ethnicity, which we know has over the years informed Kenya's political patterns. And then the other platform is, of course, a platform of gullibility. If one were, however, to closely interact with historical evidence and facts before us, they would see that, in fact, Prime Minister Raila Odinga was very much opposed to the idea of taking these matters to the International Criminal Court. Together with President Mwai Kibaki, they tried to lobby members of parliament to enact a constitutional amendment that would set up a special tribunal for purposes of these trials. But it was the same individuals who went on to politicize the process, who were very loud, saying to the effect that we should stop being vague and say that it is the Hague.
Up to this point, the conversation has been the extent to which the ICC cases will affect those who have been mentioned, and perhaps how their various ethnic groups will react to those cases. But the question remains, there are thousands who are affected by the 2007 violence. To what extent has the government really tackled that issue in terms of resolving the issues that emerged from that violence, some element of retribution and compensation to those who were affected?
That is the forgotten agenda. The agenda of justice, the agenda of restitution, retribution has been forgotten because quite early on, the political hustings came to bear, and we saw that quite early on, people started talking politics. Questions of justice, of the victims of the post-election violence have been forgotten. And even in the ongoing dialogue, we are not asking about whether they are about to be restituted. We are talking about whether the 2 with presidential ambitions are now going to come together and perhaps win the election or sponsor somebody. I think our matrix of priority is completely skewed.
Well, that was political analyst Barrak Muluka speaking to us from a short time ago from Nairobi.